you were just speaking on this, you mentioned that in some circumstances, both lost profits and disgorgement could be awarded to plaintiff. What factors justify awarding both remedies?
That's a very good question. Thank you. This is similar to patent infringement damages, where a plaintiff can be awarded both lost profits on the sales it lost and a reasonable royalty on the remaining sales made by the defendant. Similarly, in trade secret misappropriation cases, it may make sense to award both remedies if the expert's analysis shows that only some portion of defendant sales would have been plaintiff's lost sales. In that situation, plaintiff's lost profits on a portion of the defendant's sales would be added to the disgorgement of defendant's profits on the remaining sales, not included in lost profits.
Elizabeth, this is Avi Skoff, could I speak to that as well?
Yes, please.
Yeah, so the reason you would award both is because that's what the statute says. The UTSA and the DTSA both provide for an award of both unjust enrichment and actual loss. You get the part of the unjust enrichment that is not covered by the actual loss. So in other words, unjust enrichment that is covered by the actual loss is if, let's say, the plaintiff is able to prove that they would have sold 1,000 widgets, and that the defendant who stole their formula for widgets sold 500 and the plaintiff sold 500, and you give the plaintiff lost profits for the 500 that the plaintiff lost, you would not also, in addition to that, award unjust enrichment. You wouldn't award a second amount for those same 500 sales that the defendant made. On the other hand, if you show that the plaintiff lost 500 sales of 500 widgets that the defendant made, and you award the plaintiff the actual its actual damages there, but you also show that the defendant took the information and moved into a new market that the plaintiff had no opportunity to sell into, but the defendant moved into a new market, and because it used the plaintiff's trade secrets, it was able to make sales in that new market and earn profits. The plaintiff, who wasn't even in that market, could get unjust enrichment damages based on the defendant's sales in that new market, because those sales would not have been covered by the award of lost damages. So the statute presumes that if someone is going to suffer in this scenario, it's the person who stole the trade secrets, not the plaintiff.